Tinubu has not challenged the U.S. court order forfeiture of $460,000 from narcotics trafficking in any court to date, Peter Obi tells Presidential Election Petition Court. Obi told the court that Tinubu had never challenged the U.S. court order in any court of competent jurisdiction since 1993, when the order was made till date. Welcome back to Prospect Channels TV. Thank you for coming out here. If you are just joining us, please kindly subscribe. And don't forget to give us a thumbs up. Thank you. Peter Obi, the candidate of the Labour Party in the 2023 presidential election, has asked the Presidential Election Petition Court to uphold the order of the United States District Court, the Northern District of Illinois Eastern Division, in the case in which President Bola Ahmed Tinubu of the ruling All Progressive Congress (APC) forfeited the sum of $460,000 as proceeds of narcotics trafficking and money laundering. In his final written address, in response to the final written address of President Tinubu and the Vice President Kassim Shettima at the 2023 Presidential Election Petition Tribunal, Obi told the court that Tinubu had never challenged the U.S. court's order in any court of competent jurisdiction since 1993, when the order was made to date. He said that his submission is predicated on the decision of the United States District Court, the Northern District of Illinois Eastern Division, in case number 93C4483, which ordered that the funds in the amount of $460,000 in account 263226700 held by First Heritage Bank in the name of Bola Tinubu represent the proceeds of narcotics trafficking or were involved in financial transactions in violation of 18 U.S.C. 1956 and 1957. The decision stipulated in the order is tendered in Exhibit PA5 before this honorable court. The above order made by the United States District Court was square to a settlement order of claims to funds held by Heritage Bank and Citibank, wherein Bola Tinubu, the second respondent, and others claimed ownership of the sums in the account. The second respondent, to date, has not challenged the order of forfeiture made by the U.S. court as shown above. Obi noted that it is important to underscore that the proceedings in Exhibit PA5 above, the forfeiture proceedings, the order was based, among other things, by the revelation findings in the affidavits of Kevin Moses, a special agent and investigator on financial crime, money laundering, and narcotics trafficking, inter alia, that interviews with investigators from the U.S. Customs Service disclosed that the address at 7504X Stewart Avenue is known as a drop-off point for packages from Nigeria that contain white heroin, and that in the application to open his account at First Heritage Bank in Chicago, Tinubu, second respondent hearing, stated that his address was 7504 South Stewart, Chicago, Illinois. According to him, the provision of Section 1371D, or in brackets, of the 1999 Constitution is clear, explicit, unambiguous, and clearly provides as follows: a person shall not be qualified for election to the office of president. He is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatsoever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority on him for any other sentence imposed on him by such a court or tribunal, or emphasize supplied. He added, we respectfully invite your lordship to uphold that the above subsection by the use of the word or in the several instances envisaged therein envisage a disjunctive meaning and interpretation for those several instances as such. The ordinary plain meaning of the subsection is that a person shall not be qualified for the office of the president if, among other things, he is under a fine for any offense involving dishonest or fraud by whatever name called of any offense imposed on him by any court or tribunal. It is submitted that the order of forfeiture made against the second respondent by the U.S. court as reproduced above constitutes a fine, and it is in respect of an offense involving dishonest or fraud by a court. We do respect the submission on page 22 to 25 of the written address are incorrect and do not reflect the actual position of the law. It submitted that the misconception of the second and the third respondents to the effect that a conviction must exist before a person will be disqualified from contesting for the office of the president, and which said misconception stems from their unfortunate aberrant misguided the irrelevance on section 137 1E or in brackets of the 1999 Constitution. The petitioner's case is not based on section 137 1E, but rather on the provisions of section 137 1D of the 1999 Constitution. The second and the third respondent further attempt to discredit the evidence of PW1 by stating that he